Okay, so I'm going to be talking about the relationship between practical ethics and law. I do have some, I know that Liz asked us to put together some additional reading. So I will also provide just a few readings which might be of use to anyone who's interested in these questions. And if you, so I think that the idea is that I send these to Liz, or we put them on the website. But in either case, you're also welcome to write to me, and then I can also provide you with resources there. So, okay, I'd like to begin with two vignettes from capacity law. I think these will help us conceptualize some of the questions which are of interest to those of us who are working at the intersection of practical ethics and law. This is a case from 2004 that appeared before the High Court. It's from capacity law. So I'll just read this, so I'll just read this. So it's about a patient, Miss T, with borderline personality disorder, who refused a blood transfusion because she believed her blood was evil. She worried that adding more blood to her body would increase the volume of evil in her and make it more likely that she would do evil things. The court in this case held that the patient's worry was based on a misconception of reality, so unreasonable that it was to be treated as evidence of a disorder of the mind. That evidence eventually contributed to a finding of incapacity in respect of refusing treatment. Now, the question before the court was, of course, whether Ms. T had the capacity to refuse the treatment. And as you can see from the description, the reasoning that Ms. T provided in her refusal itself constituted evidence that there was an impairment. That evidence was adjudged alongside other evidence from, for example, her psychiatrist and her carers about her capacity to refuse treatment. This is the first vignette. There's another one. This one is about unrealistic thinking. A patient, ER, with severe and enduring anorexia nervosa reported that she had no desire to die and that she wished to take steps in order to avoid that outcome. But she evaded meals as part of her treatment, engaged in behaviors to appear higher in weight in order to trick staff at her clinic, and at times attempted to justify her drive for thinness by relying on distorted beliefs about her weight. The severity of the disconnect between her stated ends and adopted means constituted evidence of what the court called unrealistic thinking, and an inability to act rationally in respect of her treatment options, as a result of which she was found to lack capacity. This is a case which appeared before the Court of Protection just a few months ago, so it's quite new. It's a case which I'm working on in some of my recent papers. And here too, what is interesting is that the evidence that was used to adjudge the ER's capacity was her reasoning. So now that we have these two vignettes, I'd like to, the rest of this discussion is going to be about two key themes. The first is about the relationship between law and values, and the second is about the role of reasonability. So I'll talk for maybe 20 to 25 minutes and then open it up for questions. So I think that leaves us with another 20 minutes of questions. So there will be plenty of time to discuss. I will, as you can tell, I'm going to be focusing on an area of law which I just happen to be working on at the moment. But if you have questions which pertain to other areas of the law, we can also address. I mean, I hope that I can say something about those other areas, but this will mostly be about medical law. So one way to think about the law is that it provides state authoritative reasons for action which are sanctioned by the state. This distinguishes the reasons that the law provides from other kinds of reasons, such as the reasons that you might have in a game of chess, which also has rules, but it's not sanctioned by an authority, such as the state. Maybe the rules are sanctioned by some other authoritative entity, maybe the International Chess Federation, but not the state. So that what distinguishes the law in that regard is that it's state sanctioned. So that's one way to think about the law. So it provides us with reasons for action. But what's a reason? The dominant way to think about reasons today in philosophy is that they are facts which count in favor of some kind of action or belief or emotion. But then you have the question of what is it to count in favor of? And that takes us to the question of what is a value? And a value is itself oftentimes explained in terms of reasons. A value is a fact which provides the sort of features that produce the relation of favoring. Now, this might seem pretty circular, and it is actually deliberately circular, at least in the contemporary literature. Reasons are explained with reference to facts, and they are facts which reflect relations of favoring. The relation of favoring is explained by values. And values in turn are also explained through the relation of favoring. So it is a bit circular, but these are basically axioms in the philosophy of normativity today. So any talk of reasons or values or facts, you'll find that they're always intertwined and they're constantly referencing each other. And it's as Derek Parfit liked to say that when we think about reasons, values, and facts, it's oftentimes, because they're axiomatic, it's difficult to provide very clear-cut definitions, which are often not circular. And the best way to understand them is actually to provide examples. Now the question is, when do laws count as reasons? Well, there are two main views or ways to address this question. One is through the tradition of natural law, which says that, theorists such as St. Thomas Aquinas or more contemporary writers such as John Finnis, they argue that something is a law if it has a value-based foundation. If the value-based foundation is not defensible, then that thing, whatever claim that is being offered by the state, will sometimes fail to count as law. That's the first tradition. I mean, of course, this is a very rough way to talk about it. But the second tradition is called legal positivism, and it's sort of a school of legal philosophy which dominates places such as Oxford. Legal positivism holds that something counts as law if it's posited in the right way by the authorities. And that's all you need for something to count as law. Now, of course, you can have bad law, but it still counts as law. Now, going back to the capacity assessment. So if you recall our two vignettes, this section, which I'm going to read to you, is from the Mental Capacity Act 2005. It provides a rubric that the courts are supposed to use to assess whether the person before it has the capacity to either refuse treatment or the capacity to litigate. So recall that these are the two vignettes. So remember, Miss T refused the blood transfusion because she believed her blood was evil. And then the second one was a patient who was who exhibited in the eyes of the court unrealistic thinking. Now the question is, how did the court arrive at these conclusions? Well, there's a section in the Mental Capacity Act which is meant to guide the reasoning of the courts. Here it is. It says that the ability to make decisions. For the purposes of this section, a person is unable to make a decision for himself if he is unable to, one, understand the understand the information relevant to the decision, namely the decision to refuse treatment in the case of 2 patients from our vignettes, is unable to retain that information. And retain also means that you're able to apply the information to yourself. To use or weigh that information as part of the process of making the decision. And D, to communicate this decision in some way. This is from the Mental Capacity Act. It's actually it's a restatement of something that occurs in the literature in capacity assessments. It's called the 4 abilities model. And as you can see, there are 4 abilities here. Now, the typical sort of workflow is that you have a patient that appears in the clinic or the hospital. The doctors or the carers, they might have a reason to suspect that the person lacks the capacity to make a decision. Perhaps they have some sort of mental disorder, or perhaps they're heavily intoxicated. Then what happens is that there's an assessment in the clinical context using assessment tools such as something called the MacArthur Capacity Assessment instrument. There are other assessment tools, but basically they state what you see here, and they have ways of testing each of these. Now, what's very interesting in this model is, in my opinion, item C, the use or weigh feature, which is essentially the ability to reason. So when we are thinking about these 2 vignettes, we are really thinking about the patient's ability to use or weigh the facts in the relevant way. Yeah. Okay. So one of the before you read the slide, let me say a few things. One of the reasons as to why you have this framework is that it's meant to allow clinicians and judges a way to avoid the messy, thorny business of judging the values that a patient uses to motivate their reasoning. It's meant to provide a strictly sort of procedural way of engaging the reasoning of the patient in such a way that doesn't make assessments or doesn't involve judgments of whether the values that the patient is using are good values or bad values. So it's meant to be a procedural model rather than, say, a substantive model, which gets into the sort of details of whether the values that the patient is using are good ones that in fact support or either just good ones in themselves and also values which support the decisions that the patient wishes to make. But the trouble is that it's impossible, it's rationally impossible to exclude value judgments. As I say here, procedural models do not exist in a sort of value neutral vacuum. At base, they're justified by some conception of what would be valuable to promote by setting them up in the first place. So anytime we have a system of rules, whether it's the 4 abilities model, this, or any other system of rules, we need some kind of justificatory basis on which we can establish the rules. Otherwise, why have those rules? Why not have some other rules? Well, you need some kind of justification for the rules that you do have. This tells us something, that one, that even procedural models, they rest on evaluative or value-based foundations. And this is just a irrational requirement. Because anytime you have alternatives and you are required to, or you even want to select between the alternatives, you have to provide some kind of reason which privileges one alternative over another. It's just a rational requirement. And that sort of privileging is always value-based. Now, here's another, this is not another, but this is one thought experiment which I think is sometimes helpful in thinking about the relationship between values and facts, and how we assess people's reasoning. Now, suppose that A warns B that a lorry is approaching at speed, and that if B wants to cross the road, B should be careful not to step into the lorry's path. B thanks A for the warning, but protests that A's understanding of how our bodies fare in high-speed human-lorry interactions is mistaken. There's nothing to fear, says B to A. Unfortunately for B, A was right. In stepping into the path of the lorry, B is fatally struck. Looking back, we might say that B ought to have listened to A. We might also say that B ought to have had maybe working knowledge of the physics behind high-speed human-lorry collisions. But is it true that these oughts are evaluative? That is to say, do they rely on values for the rational force? Now, I think that the answer is yes, in two senses. One is a sort of contingent sense, and another is a non-contingent sense. So let me go through the contingent sense. Contingently, the answer is a clear yes. If B valued their life and other things being equal, then they ought to have listened to A. Or if B valued their life, they ought to have understood the relevant facts correctly. Now, the answer is also a clear yes, even non-contingently. B ought to have relied on true rather than false premises concerning human-lorry interactions, because that's on the cards analytically in what it means to reason correctly. So analytically here just means that it's built into the definition. If you want to reason correctly, you are required to rely on true rather than false premises. If you rely on false premises, you're not reasoning correctly. That's what it means for something to be, in this context, to be analytically on the cards. Now, what we learn from B's demise is that understanding the facts of one's circumstances involves correctly reasoning. One component of which, namely soundness, is biased in favor of and assessed with reference to what is in fact true. Now, let me say something about what I mean by soundness. In classical logic, specifically in deductive reasoning, there are two ways that a piece of reasoning will be a good piece of reasoning. One is that it's valid. So that entails that, which just means that the conclusion follows from the premises. And the second criterion is soundness, which basically is that the premises which are deployed in the reasoning are in fact empirically true. So you can have a valid piece of reasoning which uses false premises, but is not sound because the premises are false, and that piece of reasoning will be deficient in some way because of its reliance on false premises. And then you have soundness, which is the sort of ultimate test, because it involves assessments of validity. So not only do the conclusions have to follow from the premises, but in fact, the premises also have to be factually true. So that's soundness. Now, I think this is my last slide. So, and then we can open it up for discussions. So B's story about the lorry also tells us something about the work of the courts. And this takes us back to the two vignettes from the beginning. In contexts where the courts are required to assess the soundness of an individual's reasoning, say in capacity cases, judges must, if they are to do their work, deploy conceptions of reasonability. Such conceptions often, if not always, rely on judgments of value, insofar as they involve placing thresholds that distinguish good reasoning from bad reasoning. Now, what's reasonability? This is an extremely thorny question. One way to think about reasonability is that it is a demarcation of conclusions which are generally accepted to be eligible given the facts of this, or given the circumstances. If the conclusion is not eligible, then it's unreasonable. Now, what constitutes eligibility is oftentimes socially constructed. So sometimes you can have contexts in which experts believe that a certain conclusion is true when it in fact is false. But it would be unreasonable for a non-expert to question that the conclusion of the experts, because one, they don't have the relevant expertise, so they just don't have the requisite training to be able to judge what's going on. So it would be unreasonable for them to hold that for them to conclude that the views of the experts are in fact false. And it also means that you can have reasonable views which are in fact completely false. Say that you think that you have all of the relevant considerations in hand, whereas in fact you might not. So you arrive at a conclusion which, given the facts that you think that you have, are supported by those facts, when in fact there are other circumstances which completely evaded your perspective and which render your judgment false. But your judgment is still reasonable because you relied on facts which you thought were relevant, and you excluded facts which you thought were not relevant. So reasonability is about deciding which conclusions count as possible in a sort of, I guess, reasonable way, and other conclusions which fall outside that sort of demarcation. Now, in capacity cases, so if we go back to the two vignettes, I think this is really going to bring it home. The case of Miss T, the court decided that there was a misconception of reality which was so severe that it was to count as evidence of impairment. But there's no analytic, legal, or clinical test that would allow somebody to conclude that the misconception of reality is so severe as to count as evidence of impairment. No clinical test provides for that kind of judgment. What the courts have to do is to set a threshold of reasonability that basically says anything that falls on one side of the threshold will count as being so unreasonable as to count as evidence of a disorder of the mind, and anything that falls on the other side of that threshold does not constitute such evidence. Now, where the courts place that threshold will depend on a judgment of value as to what constitutes good reasoning, sound reasoning, and what does not constitute such reasoning. And so too with the case of ER. There is no clinical test for unrealistic thinking. There is no clinical test for acting rationally in respect of one's treatment options. So the courts, again, are required to sort of rely on, this is now a problematic aspect of what the courts are doing. They're relying on an unarticulated conception of reasonability in order to arrive at these judgments. Now, part of my work is trying to flesh out what this conception of reasonability must be in capacity law. For those of you familiar with other areas of the law, of course, you'll know that the conception of the reasonable person does a ton of heavy lifting right across the law. And these standards of reasonability are often described as obscure, vague, uninformative, etc. And yet they're still articulated. For example, the conception of reasonability which occurs in public law. But in capacity law, where the conception of reasonability is also doing a ton of work, it's unarticulated, which means that it really is a mystery what kind of reasons the courts are relying on in order to conclude that Ms. T's reasoning is so severe as to be a misconception of reality. And in the case of ER, that their reasoning is unrealistic, or their thinking is unrealistic. I think that's all I wanted to say. So going back to our two key themes, I said a few things about, well, I provided a general sort of framework for thinking about the law. And I argued that laws are in fact reasons for action, and reasons for action can only be explained by reference to values. And then I sort of talked a bit about the role of reasonability in capacity law, and argued that where the courts place the threshold of reasonability is in fact a value-based judgment. And I think, how long do I have? Okay, I've talked for 25 minutes on the dot, and I think I can stop sharing now and open up the floor for questions.